Yes, I am. Recused.
Thank you, sir.
Give that to Judge Boxford. Get your pink slips. No, sorry. Okay, so we're now Quezada.
Good morning, Ms. Celio.
Good morning, Your Honors. May it please the Court. My name is Catherine Celio, and I represent the Commonwealth on this appeal. I ask this Court to reverse the motion judge's allowance of the defendant's motion to suppress. The touchstone of Article 14 and the Fourth Amendment is reasonableness. So the question before this Court is whether Officer Horan was acting reasonably based on the totality of the circumstances when he seized the already running defendant. And I submit to you that the answer is yes, based on the community caretaking exception and based on a reasonable suspicion analysis.
Nothing illegal, nothing, go ahead, excuse me.
Even if we were to assume that the community caretaking function is the valid approach here, the police officers, isn't the police officer's response inappropriate for community caretaking once the defendant ran away, thereby alerting the police officer that the defendant wasn't in harm's way, that in fact he was fine? He was well enough to run and smart enough to run away from the police officer.
Well, I would have to disagree with that. That was what the motion judge found, and that was his basis. But I think that it was reasonable for the officer to think that the defendant's reaction after he was needing assistance, had a bandage on his head, was staggering, seemed appeared out of it.
Was being helped by someone.
He was being helped by someone.
the
He was
street.
in such a debilitated state that he needed to be helped by someone, that he took off, and that his judgment was compromised.
But by taking off, he indicates he didn't need any help in walking or indeed even in running.
He indicated that his legs worked, and I guess...
And his mind worked.
No, I would have to disagree with that, because it could have been...
He didn't run towards the police.
I mean, I didn't hear you, Your Honor.
He didn't run towards the police. He ran to get away from them.
Help.
I mean, isn't that smart?
If you are carrying something illegal,
And if you are in the company of a known
convicted
person,
Well,
and you see the police, you want to take off.
I do agree with both Your Honors that those facts and circumstances are very suspicious, but I don't think
They're not suspicious. If the whole point of community caretaking is that you don't suspect criminal activity, you are concerned about the well-being. So it's a freezing cold night, there's a car pulled over at the side of the road, the engine isn't running, and you can see that there's a body lying down, right? You don't suspect criminal activity.
all I was saying is those objective circumstances do add up to reasonable suspicion, but I'm saying that they also objectively add up and to the officers having a reasonable belief that at that point the defendant was still in need of aid.
So they chased him and tackled him.
No,
Okay.
that was never.
right.
The judge made no factual findings. He credited the officer as sole testimony. On page 56 of the transcript, he said, "I find it unnecessary to make any factual findings." And what the officer testified to was that on direct examination, when asked the question, when you stopped him, did you grab him? Did you tell him to stop? And the answer of the officer was, "I grabbed him, and we both went down to the ground."
May I just ask you this? Doesn't it really go back to the point in time when the police officers observed the defendant in the presence of Billy Schofield or Schofield, whatever his name is? Isn't that really the point at which the police became concerned about this fellow who they saw walking with a bandage and who seemed to be in there? In other words, had it not been Billy Schofield, perhaps the police wouldn't have even had an interest in this.
Well, that's what the motion.
Yeah, and that's what I'm asking you to respond to.
That was the motion judge's musings, but what the officer testified to is that based on the defendant's appearance, he thought a couple of things. One, the defendant could have been a victim of a crime. The defendant was in need of medical assistance.
Excuse me, why would the defendant have been a victim of a crime?
just because of the fact that he was needing assistance and he seemed out of it. It was just something based on the officers.
Wait a minute. When somebody's walking down the street and, is kind of looking blurred or something, he's been the victim of a crime?
No, also, I think his head was
He had a
bandaged.
bandage.
His
He had
head
a
was
bandage
bandaged.
on.
No, I understand. So your head is bandaged. There are lots of reasons why your head is bandaged and why you might be, but why that it makes you a victim of a crime?
Well, I think that you could think the officer testified he could have been a victim of a violent crime, and I think it was reasonable based on
Why?
because he was injured and because
It can't be that every injured person, it's reasonable to think he's been the victim of violent crime. I think one of the problems here is the Commonwealth keeps mixing up community caretaking. And I suspect that knowing if the officers knew, which they did, didn't they, who at least one of the men was, they probably concluded that he had himself been, may have provoked an attack.
I think it could have been reasonable that they thought, I don't know if Billy Schofield, the defendant was a victim of a crime of Billy Schofield. I don't know, but it was reasonable. The officer had a reasonable belief, and this is under the community caretaking, that the defendant was in need of aid.
Ms. Celia, let me ask you this. You started off mentioning Article 14.
Yes.
Does Article 14 deal with community caretaking?
Not literally.
Not literally. I mean, this court has determined that the community caretaking function.
I'm not saying we can't say that there's community caretaking. I'm just asking you whether Article 14 deals with community caretaking.
Definitely the Fourth Amendment does, as recognized by the United States Supreme Court. I mean, I don't think why Article 14 wouldn't encompass community caretaking also.
What's the language of Article 14 that would put a limit on community caretaking?
I'm not sure about that, Your Honor. I'm sorry.
I have a question for you that I was interested in. Is it the Commonwealth's position that the police could stop anyone in that particular community because of concerns about drug use or the possibility they had some mental illness issues?
No, just someone on the street in that, no,
Yes.
definitely not. The officer
Well,
testified.
wasn't that part of what the officer said, that he thought that a lot of people in Charlestown did drugs or might have mental issues?
No, what he said was that based on the defendant's appearance, he was staggering, as I said, a bandage on his head, he appeared disheveled, out of it, was hanging onto someone, that he, one of the thoughts that went through his mind, that he could have gotten out of a psych ward or could have been overdosing on drugs, which he said were common occurrences that he had found in Charleston. But he didn't say that. It wasn't necessarily, it was because of the defendant's appearance in that situation that he thought those things. Not anybody in the Bunker Hill housing development would be on drugs or just gotten out of a psych ward.
May I return to Article 14?
Correct.
As I understand the United States jurisprudence on the Fourth Amendment, it has said that where there is community caretaking, it is not inconsistent as a general matter. Police don't stop and talk to to citizens on the street. It's not inconsistent with with the Fourth Amendment.
Mm-hmm.
Article 14, as you know, talks in terms of searches and seizures. You're not allowed to search and seize.
Right.
If, in fact, what was going on here was community caretaking, once the person ran away, you're not allowed to search and seize, and community caretaking doesn't say that you therefore throw out Article 14. Why does the community caretaking not just drop out of the picture entirely? He's running away.
Correct.
He's running away.
I guess I'm a little. Are you saying that the community caretaking no longer applied because he ran away?
Yes.
But at that point, his actions could have been consistent with the fact that he still was in need of aid. legs worked, and I definitely say that, but it didn't mean that he was of sound mind. In fact, the officer thought that in some ways his judgment could have been compromised because he was exhibiting bizarre behavior consistent with maybe overdose, I think he said, of angel dust or something other than that. And so there was still a need for him to check on the well-being of that individual, even though there's also another plausible answer, and as this under the reasonable suspicion, that his behavior of changing his debilitated state to running also warranted the officer an objectively circumstances for a reasonable person to believe that the defendant was engaged in criminal activity.
But isn't that a sort of classic case of pursuit becoming the reason for the reasonable suspicion by itself?
No,
I mean,
because
the flight becoming the reason for reasonable suspicion?
are you saying the defendant was not seized until after he ran?
Right, but just the fact of running, you say, is enough to give reasonable suspicion?
No, because you have
Wasn't seized until after he ran?
after he started running, and the officer ran after him and said, "Stop." He got out of the car and said, "Can I?"
Do you
talk?"
agree that he was seized as soon as the police officer started running after him?
Well, I would think the defendant started running, and then the officer ran, and at some
But
point,
once he started running,
well, there's nothing since the defendant had started running. There's no show of authority on the officer's part at that point for a defendant, a reasonable person, to feel that he was not free to leave. But once the officer said stop, then that is the show of authority that this court has recognized that would make a reasonable person.
What in the running? I guess what I'm asking is, where do you find in this set of circumstances, including obviously the running, that somehow materialized some reasonable suspicion other
Right.
than the running?
Getting back, well, one, you have a high crime area, as this officer testified. He was on the walking beat, but as this court has recognized, that fact can be seen within the whole totality of the circumstances. You have him hanging on to Billy Schofield, who the officer knew to had recently gotten out of prison, and as this court said in Commonwealth versus Kennedy, the fact that defendant is engaging with a known criminal, it can be.
excuse me, the known criminal was helping him?
Well,
Wasn't the known criminal helping him?
Well, at that point, he was assisting him, but to cross the street. But the
And
fact that
there was no sign of resistance. Get away! You've just attacked me. Go away.
but I don't think that I just think the fact that he is associating with him, and at that point, as said in Kennedy, that that can be a factor in the reasonable suspicion analysis. And then I think also what was significant, that the defendant was in this debilitated state such that he needed assistance, and he's abandoned that. He started running, as similar to what this court said in Commonwealth versus Sykes. The fact that the defendant abandoned his bicycle in an attempt to evade the police was highly significant in this court's decision. And I think in that way, a defendant abandoning, hanging on, having just hung on to the officer and started running, that added into his flight, which can also be another factor. And I think those four things would give a reasonable person belief that the defendant was engaged in criminal activity.
Have we accepted here, as opposed to the appeals court, this community caretaking thing?
Well, in Commonwealth versus Murdo, this
Haven't
court.
we only done it in motor vehicles at night?
No, that is correct, but I don't think this court has had the opportunity to apply it into individuals on the street.
So in Murdo, we flat out said, okay, we accept this somewhat
Yeah,
vaporous doctrine?
yeah.
Well, we said it only in pretty extreme circumstances, correct?
You said when the situation warrants an officer to check on the welfare of an individual.
Why is the appeals court incorrect to say, you see an injured man, and I'm quoting, certainly the police would have been warranted in offering aid, but chasing the defendant and ordering him to stop went beyond the scope of the community caretaking function, citing to Murdo and Evans.
Because the appeals court was under the impression that the community caretaking exception only applied, I think, to automobiles. And
I mean, they approach this as a police hostility kind of thing, instead of walking up perhaps and saying, can we help you? Is there anything wrong? Can we help you? Do you need medical assistance?
Well, the officer asked us to speak for a minute, and we don't know what the officer would have asked next. Can we help you? Because at that point, the defendant started running. And if this court has no further questions?
Well, wait a minute, let's get to the reasonable suspicion.
Okay.
So is there anything that you want to add on the reasonable suspicion? So there was flight, there was
High
a
crime area.
and we knew that he was being assisted by somebody who had previously been convicted.
Correct. And the fact that he had abandoned his debilitated state. He goes from...
Wait a minute. If you abandon your debilitated state, that is an indication that's suspicious?
No, but the fact that the defendant was going to such extremes to to evade the police.
That's flight. Why is that different than just flight?
Well, because I think it would be different if you just walk up to an individual who's just conversing and then take off. I mean, this was an individual who was trying to show that he was injured or debilitated in some way, and then went from that to running, which I showed even more of him wanting to evade the police at that point.
Celia, just help me out, and maybe it's in here. What happened to his companion that
He
night?
stood there.
What happened to him? Was he
I'm
arrested?
I'm not sure. He wasn't arrested. From the transcript, it didn't. There was no indication of whether or not he was arrested, but they weren't tried together. That he just stayed there, and I don't think they found anything on him.
Okay. Thank you, Ms. Celia.
Thank you, Your Honors.
Ms. King?
Good morning, Your Honors. Frances King, representing Yasmani Quezada. I'd like to begin by something that Justice Greene asked my sister, and that was the words of the police officer. When I was reviewing the documentation over the weekend and last evening, it suddenly struck me that the words that Officer Horgan said to both of the individuals in Charlestown that day was, "Can I talk to you a minute?" Not, "Can I help you? Do you need assistance? Is there something I can do for you?" Those words are very telling in this case. Clearly, this was an investigatory situation where the police officer, both police officers, it should be noted that both police officers exited their vehicles. I'm not quite certain if that's clear from the briefs or the appeals court decision.
It's the middle of the day, correct?
Pardon me, Your Honor?
It's the middle of the day.
Yes, it's 1 o'clock.
Broad daylight.
It's 1 o'clock in the afternoon in Charlestown. And as this court well knows, being in a high crime area in and of itself is not sufficient. There are many law-abiding people that live in high crime areas that...
So 2 officers, they were in plain clothes?
2 officers were in plain clothes in a so-called unmarked Crown Victoria. Approximately 1 o'clock in the afternoon in Charlestown, yes.
Which had big grates in front of it and blue lights,
Yes.
thinly disguised.
Correct, Your Honor. And it also should be noted, Your Honors, that these 2 individuals, while crossing the street, were just crossing the street in a slow manner.
Well, certainly the officers had every reason to stop and make inquiry of them. There's nothing wrong with that.
No, there is not, Your Honor.
In
No,
fact,
there
we
is not.
encourage officers to take some initiative when they see something that might be problematic to at least make inquiry, check in. And they did that. Let's assume that's what they did. And this fellow took off in a sprint. Why doesn't that put us into the category of the officers having reasonable suspicion that a crime has been committed?
Well, because flight alone is not enough. And prior to that, we have 2 officers who absolutely had every right, police officer, and can stop an individual at any time to conduct a discourse of conversation. The Fourth Amendment in Article 14, the inquiries turn on rapidly evolving factors. So we have 2 individuals who were just crossing the street.
Well, one was staggering and holding on to the other.
Correct. And again, with respect to the community caretaking issue, the district court, the appeals court, and myself would argue that if there is a problem, a health problem of any kind, it's being attended to. He's being taken care of. And there's a bandage on his head. We have absolutely no indication whether there's any blood on the bandage, the description of the bandage, but he's being attended to, and they do cross the street. In some of the federal cases on the community caretaking, they have deviated from automobiles. One case indicates that it would be foolish to assume if someone is convulsing in an automobile and need assistance, that they would not need the same assistance if they were walking across the street convulsing. We don't have that here. And in every single federal case, we have one person, one individual in one of the Commonwealth's cases was in the middle of the street at night in dark clothing, waving his hands and acting erratic. Well, the community caretaking, I would argue to you, should be obvious. It's a function of the police in situations such as that. Here we clearly have Officer Horgan seeing Billy Schofield. They know Billy had just been released from jail. What's going on? They're up to something. They had actually crossed the street. They were walking down the street. Both police officers exit the vehicle. Can I talk to you for a moment? That, I would suggest to you, is a precursor to a Terry stop.
But it was not a stop. That was not a seizure for constitutional purposes. They have every right to do that without
Correct.
implicating any constitutional rights.
Correct. And I did not mean stop in a constitutional sense. It was a citizen-police officer exchange that did not bring about a constitutional analysis at that point. However, it's a pretext and subterfuge to assume that this is a community caretaking function at this point. The police officers, the both of them, approached the individuals. Billy Schofield stood there. They both looked at the police officers. My client said nothing and ran away. Flight alone is not enough. At this point, they have nothing else. There is absolutely no indication of any crime being committed, about to be committed, or having been committed. And the police officer chases my client. When does the stop occur? Again, the constitutional analysis is a rapidly evolving set of factors. The district court judge found the stop occurred when the police officer yelled stop. It also should be noted that Officer Horgan chased my client for about a minute. I would suggest to this court that's a long time. He chased him down Medford Street and over a grassy pathway and then tackled him. For the Commonwealth to tell you today that when he tackled him to the ground, or they both fell together, that was a concern that he was okay, does not even pass the straight face test. He tackles him to the ground and he's worried about his well-being. This is clearly subterfuge and a pretext for an investigatory stop, and they didn't have any reasonable, articulable suspicions of any criminal activity.
So for constitutional purposes, the stop or seizure occurred when the officer yelled stop in the middle of the chase, or as soon as he
When he yelled stop at the very last, Your Honor, when he put his hands on the defendant. Even at that last gesture, there was absolutely no reasonable...
Is it clear before that point, or is it a reasonable inference down Medford Street across a grassy area, is it a reasonable inference that your client knew that the police were chasing him?
Yes.
Why is that not the seizure?
Your Honor, I would argue that it is.
The appeals court has said it's the seizure and the stop.
Correct.
But if it is a reasonable inference that this man turned and ran and knew that he was being chased by a police officer, if it's the police officer has every right to say, can I help you, can I ask you a question? But once you don't want to do that, and you want to leave and you want to run for a minute, you can do that as a citizen.
I agree, Your Honor. Commonwealth versus Stout.
Of course, in a kind of a comic way, the police at that time know that the defendant doesn't need medical help because he's running like an Olympic sprinter.
Exactly, Your Honor. Exactly.
Can I just ask you, in the light most favorable to the Commonwealth, the appeals court pointed, summarizing the Commonwealth's argument, which I think Ms. Celio has repeated here, we've got flight presence of a defendant who's recently been released and high crime, and then the defendant's manner and demeanor suggested that he was possibly under the influence of narcotics, which in turn supported an inference that the defendant might have possessed other not yet ingested narcotics. What's the evidence of that in the light most favorable to the Commonwealth?
Your Honor, there is no evidence of any narcotics, ingested or otherwise. If we had a call, an anonymous call from a neighbor in the area, there were some drug dealers in the area. I see people exchanging something in the back of my yard. This is sheer speculation on the part of the Commonwealth.
You don't
There's-
have any of that. You didn't have
No,
any
we
of
don't
that.
have any of that.
You got a
Well,
little
the
bit of-
officer was saying, wasn't he, that in this neighborhood, I know that they do angel dust, and wasn't that part of it?
It is part of it, Your Honor, but I know who does angel dust. Billy Schofield just got out of jail, so we don't know what he was doing, and we don't even know what he was in jail for. So there is no evidence whatsoever of any ingestion of narcotics. There was speculation of someone being released from from my client being released from a psychiatric hospital. Where is that based in any facts at all? It was purely speculative. Good police work, of course, but purely speculative, no reasonable suspicion of any criminal activity. And again, Your Honors, the community caretaker function of the police is not here, and the Commonwealth is using subterfuge and pretext to try to bring it into this situation.
Ms. King, excuse me, the events at issue occurred on August 25th, 2004, correct?
I believe so, Your Honor.
Yeah, well, that's at least what the appeals court says. And what was the sentence? Oh, there was motion.
Motion to suppress.
It was a
Please.
motion to suppress on October 6th, Your Honor, I believe of '04, if I'm correct.
And is your client out on bail?
He is.
Okay. Thank you, Ms. King.